This conference will now be recorded.
Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, in each episode, we will be looking at stories in the law relating to digital technology from around the world, with an emphasis on data protection and cybersecurity. I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague Peter Wright. We're just going to run through some of the news stories that have been coming up this week. I will pass over to Peter to introduce himself, and then we will get started.
Yes, thank you, Amelia. Hello, everyone. My name is Peter. I'm a solicitor and the managing director at Digital Law, and hoping to be able to refresh everyone on a few stories this week, including one particularly large story involving everyone's favourite tech giant, Meta. So I'll pass back to you, Amelia, to kick us off.
Thanks, Peter. So pretty much it was the top story of the headline this week. I don't think there were any sort of news outlets that did not mention it. And so this is Facebook's owner Meta. They have been fined a record £1 billion in order to suspend the transfer of user data from the EU to the US. So the fine, equivalent to $1.3 billion, was imposed by Ireland's Data Protection Commission, the DPC, and they regulate Meta across the EU. This is a record for a breach of the bloc's general data protection regulation. And the suspension of Facebook data transfer is not immediate, but they have 5 months to implement it. So I will pass over to you, Peter, to continue with going through this one.
Yeah, thanks, Amelia. I mean, it's a massive story. It's been brewing for a long time, and it's all a bit of in some ways it's incredibly important. In other ways it isn't, and I'll explain why. So the ways that it is very important is obviously, a fine of over $1 billion shows how far the European data protection regulators are willing to go. This also shows that the mechanism of having the European Data Protection Board, made up of representatives of all of the European data protection regulators, is working insofar as it is able to almost force one of the frontline regulators, in this case the Irish DPC, to issue take regulatory enforcement of this nature when really they didn't want to. So the Irish DPC has been pretty much pulled kicking and screaming by the European Data Protection Board to have to take this enforcement action following significant complaints raised by the other regulators around Europe. So they've ended up taking this step. There is, the specific instructions with regards to now what Meta expects, what the regulator expects Meta to do, but there are implications here because while it's just saying, look, this just relates to Meta's to Facebook's data, not necessarily Instagram or WhatsApp. Increasingly, this actually has implications not just for Meta, because ultimately this is like, as a piece of regulatory enforcement, it's the same in terms of sort of giving us a bit of precedent here as a court decision, insofar as the regulator here is saying that you shouldn't be sending this sort of behavioural data to the United States from Europe, containing the personal data of EU citizens, when it is potentially open to surveillance by the US security services. And the point is, it's saying that the mechanism of standard contractual clauses, which are being relied on in this instance, are not sufficiently rigorous to mean that just because the parties involved have signed up to the standard contractual clauses does not mean that the data might not be subject to surveillance by US security services. Now, Meta will have to, they're going to appeal this. Of course they are. They've already, the minute that this fine was announced, they said, we don't agree, we're going to appeal it. Who knows if they will succeed with that or not? Will they even be able to bring any fresh information to the table for the court to say, yes, you can appeal it. You have additional information here that wasn't considered by Meta, by the Irish DPC before it brought its enforcement. But presuming it gets that far, this will then trundle on for months, probably years, through the judicial system. In the meantime, you've got the introduction of the EU-US privacy framework that we are expecting to come in July of this year. That will then mean that a new mechanism is set up as a successor to the EU-US privacy shield, which was struck down by the Max Schrems 2 decision back in 2020. And in theory, you'll then be able to have not just Meta, but all other organizations involved in international data transfers of the data of EU citizens to the US. They'll be able to sign up under the privacy framework, and that will provide a sufficiently rigorous umbrella to allow data transfers to continue in the future. The problem is that despite the political agreement and the political will on both sides of the Atlantic, the same thing could happen. We could get a Schrems 3 decision, and Mr. Schrems has already indicated he's likely to challenge the framework, and therefore the likelihood of the framework lasting long term is, or even medium term, is remote. The likelihood of it lasting more than 5 years is unlikely. The Privacy Shield only lasted 4 years. Will this last as long? Well, how long will the court case take? Given COVID delays, etc., it might be 4 years, might be a little bit longer, but this isn't, again, a long-term solution. It's a sticking plaster on the big problem of data transfers from Europe to the US. So it's almost like Meta here is collateral damage. There's the clear indication that the taking of this sort of data for the purposes of behavioral advertising, whereby Meta is collecting the data from things like the Facebook's Reel, whereby it's taking a look at the data in terms of how long you may watch a video, what the content of that video is, how long you watch that video for, what do you then scroll on to, and trying to build up from that behavioral insights into each user. The point is those sorts of transfers that in this instance have been found to be invalid, and therefore it's a matter of reappraising how that data is collected and then transferred. But we know that there are other tech firms, like, for example, TikTok, who are doing exactly the same thing. And even TikTok is relying on infrastructure in the US as well. So there is the effect that other platforms could be just as heavily impacted by this decision as Meta going forward.
Thanks, Peter. So moving on to our next story today, we are sticking with kind of the theme of regulators here because the Information Commissioner Office has issued a formal reprimand to the UK Ministry of Justice after confidential waste documents were left in an unsecured prison holding area. So prisoners and staff had access to the 14 bags of confidential documents, which included medical and security vetting details for a period of 18 days. During this time, staff challenged prisoners who were openly reading the documents but did nothing proactive to ensure the personal information was secured. At least 44 people had access to the information, which had remained on site as the contracted shredder waste removal company had not collected as scheduled. There are a lot of bits and pieces that we can unpack here, and I'm sure Peter will take us through them all.
Thanks, Amelia. Yeah, so this is always a slight concern when this is a significant data breach by the Ministry of Justice, which operates and oversees the judicial system, things like Her Majesty's Court Service, as well as the prisons probation service. And here we've got a major issue with regards to the prison estate and the fact that data. I mean, the really worrying thing here, when you look at the items that the regulator has highlighted, it's the fact that certainly it looks like staff and prisoners were just freely looking at personal data, and no one realised that this was a problem. And the penalty notice does say, look, there is an issue here with regards to the fact that no one identified it, which suggests that training was poor or indeed non-existent. And we're always banging on to our clients here about the importance of having regular data protection training. So you can say, look, we did train our staff, and they were being, through training sessions, told about the importance of identifying personal data, being told about the importance of spotting a breach. And in this instance, it looks like either they weren't receiving much, if any, training, or if they did, they didn't put two and two together and think, this is personal data and we need to do something about this. So as a result, it was the fact that this sort of breach was continuing on and on and on. It's also a reminder that not all data protection breaches are occasioned by cyber attacks. We're talking here about hard copy records. We're talking here about individuals physically looking at those records for a protracted period of time. And very often, I think when people think, data protection, they think, this is all online, and they think about encryption and security measures, when it's just as relevant when it comes to the maintaining of hard copy records and archives as well. And In this instance, the Minister of Justice has been found severely lacking. Quick final point as well is that obviously we were just talking there about Meta and their fine from the Irish Data Protection Commissioner. In this instance, the UK ICO has issued a reprimand. Now, a reprimand is not actually a statutory power contained in the UK Data Protection Act 2018. What does that mean? It means the ICO has just issued this reprimand. It's named and shamed. It said the Ministry of Justice is at fault, but there is absolutely nothing short of judicially reviewing the ICO that the Ministry of Justice can actually do. So you aren't then caught up in sort of protracted appeal proceedings of the type that we're going to have there with Meta, with a reprimand. It's just basically, here's a reprimand, get on with it. So it's a very different model when it comes to enforcement that the UK ICO, Jonathan Edwards, is following here. But we're seeing that he's certainly not afraid to hit the government over the head with a reprimand. And indeed, the notice, it clearly says final reprimand. So clearly there are ongoing issues with the Ministry of Justice, and that may then become a monetary penalty notice in due course. Who knows?
Thanks, Peter. I think it's interesting as well because we have seen quite a few different ICO fines and reprimands this year on many different forms of government due to issues between data protection and data protection rights and freedom of information. So it's interesting to see that there is a slightly different stance that's being taken with these reprimands, and it isn't always just, right, we will find them. It's taking more of a kind of tactical way of doing things realistically, because like you say, they can't appeal these reprimands.
Yeah, exactly.
So moving on then to our next story, kind of stepping away a little bit from the ICO and regulators. This story will be covering Chinese hackers using stealthy malware to attack critical infrastructure on American military bases in Guam. And this is according to Microsoft and Western spy agencies. So experts are saying it's one of the largest known cyber espionage campaigns against the US. And there could be some fairly big outcries after this. So I will pass over to Peter there.
Indeed, thank you, Amelia. So I think the big takeaway from this is that I think we've become very used over the course of the last year to stories about Russian hackers and the fact that both in Ukraine and Russia, they're throwing increasingly aggressive cyber attacks at each other in parallel with the very real and physical war on the ground. And occasionally when you've got incredibly aggressive ransomware and malware being thrown back and forth, that can mean that any system that is not properly patched and presents a greater risk could be at risk of being exploited by these very aggressive tools that are out there. And this story really is a reminder that it's not just Russia or Ukraine in the course of trying to defend itself that we have to think about here, or North Korea, which has also used ransomware as a pretty major way of being able to get hard foreign currency into North Korea, where the economy is never in a particularly great shape. It's one of their main ways of being able to access that foreign currency. So we know about North Korea, we know about Russia and Ukraine, but China is a big actor when it comes to the perpetrating of cyber attacks. And in this instance, they're carrying this out against the United States. And I think what's particularly interesting about this is the US, we had the whole spy balloon thing earlier this year where Chinese spy balloons, or what they say were Chinese spy balloons, were shot down over the US. And the US in the past has accused China of being behind significant cyber attacks on US infrastructure and indeed the US government. But in this instance, the notice has not been issued by the US government. This is issued by the Five Eyes Network, which is the US, Canada, the United Kingdom, Australia, and New Zealand. Their 5 combined security services have, in this instance, pointed the finger at China for these perceived attacks in Guam. And it's the fact, therefore, that you've got this security agency or this partnership agreement between those 5 security agencies is showing this isn't just the US who have been investigating this. It's going to be GCHQ in the UK and other security agencies involved as well. And they're all of the view, and they've all put their names to this to say we are of the view that this is China. So it gives significantly more weight and makes people think, perhaps sit up and take notice that little bit more compared to if this was just the US, that the NSA pointing the finger. It's collectively the US and its big four allies there as well, also pointing the finger and saying, we think there is something amiss here, and we think that these cyber attacks are originating from China.
I think another point to mention here is the fact that this is another example of where critical infrastructure is being targeted. We've got the American military here, and throughout the rest of our podcasts in previous years, months, we've looked at how I believe it was around this time last year that the US airlines were targeted. And there we've seen the NHS 111 that's also been targeted, which they are still yet to fully recover from. So this is just another kind of nail in the coffin where we have got those outside attackers looking to kind of shake critical infrastructure.
That's a really good point, Amelia, and I think it's actually really important that there's a lot of stories when you look in the business pages at the moment that suggest, and we're used to this in Britain, where we're always saying that we're sort of bumbling through and things never quite work quite right. But there's a lot of that at the moment, and a lot of it's been due to supply chains and strikes and the cost of living and shortages of staff, insofar as a lot of people have resigned. There's 5 million people on out of work benefits in the UK, and an awful lot of vacancies as a result. So there's this sort of perception that things aren't necessarily working properly. And it's quite similar as well when you look on the business pages, particularly in the United States, where they've got a lot of very similar problems. And I think there's sometimes the perception that you think, oh, well, this is all, everything's falling apart and it's because of the strikes and mismanagement, etc. But actually, I mean, the Royal Mail was hacked, and they're still trying to come to grips with that. And there's a lot of stories about, the number of deliveries is falling, and people are spending weeks or sometimes months before they receive post that can contain things like medical appointments. So people have actually missed medical appointments because they haven't even known the appointment was taking place until a letter comes advising them that their appointment was the previous week. But in this instance, it's actually because of, the Royal Mail has been collateral damage to a fairly significant cyber attack. And it's the same across infrastructure, where things are being put at a severe disadvantage because they're either defending from or dealing with the after effects of significant cyber attacks. And that then affects service delivery. And the UK has been on the end of a lot of this sort of cyber warfare over the course of the last year because of our support for Ukraine. Similar thing in the US, similar thing across the West as a whole. And I think it's sometimes tempting just to think that we can just attribute these problems to the very real physical issues in terms of manpower shortages, etc. But actually, an awful lot of this is actually due to fairly nasty, aggressive cyber warfare capabilities that we're seeing used. And that sort of the conflict is waging away in the digital world just as much as it is in the very real physical world as well.
Thanks, Peter. So moving on to a slightly more uplifting news story. I mean, we do tend to cover the doom and gloom in our podcasts. So this is more of a story about not common sense being, well, not so common apparently. So the Judicial Conduct Investigations Office has handed down formal advice to two magistrates. So this is on the basis of advice after two fellow magistrates sitting on a trial saw an individual using their phone during the trial contrary to guidance. And I mean, come on now, surely you know that in a trial you do not want to have your phone out and not pay attention, but I'm sure Peter can fill you in a bit more on this.
Yeah, I mean, for example, jurors aren't supposed to have their access to mobile phones when you're on the jury, because of course you could then potentially see news stories, coverage, social media about the case that you are being a juror on. So it's not particularly great then when potentially you've got a magistrate, one of three magistrates in the lower court, who was supposed to be making decisions on a case before them, gawping at their mobile phone instead of actually dealing with the matter at hand. And this happens quite a bit increasingly because, let's face it, people are now glued to their phones. Just walk through a bus or a train or the average cafe in a city centre, and everyone's on their phone. And we sometimes forget that there are occasions when you shouldn't be on your phone. And clearly, in this instance, the magistrate has thought, oh, I just want to check something, or I just want to read something, or suddenly found that their attention has wandered, and they're looking at a phone, and that has very real consequences here for them. But I mean, this is similar actually to a story a couple of months back where a member of Parliament here in the UK actually ended up having to resign as an MP because they were using their phone in the chamber and also in a committee room. And not only were they using the phone, they were using the phone to look at porn. So they were overseen with pornographic images on the screen of the phone while they were looking at it. And despite protestations by the MP that, oh, I wasn't looking for that, I was looking for something entirely different, and it just suddenly appeared there twice. It just kind of illustrated the point that, you were being paid to actually, you know, engage in debate and engage in scrutiny in Parliament, in committees, and in the chamber, and you shouldn't really have been on your phone. And I know there's always the excuse of, oh, well, I was looking at the very important constituency business. Well, in that instance, clearly it wasn't, was it? But it's a reminder that there are occasions when you don't want to be scrolling through your phone. And, you know, when you're sitting as a magistrate or when you're sitting as an MP, those are significant examples. And generally, in the workplace or at school, you shouldn't be gawping at your phone. That's what it simply comes down to.
Thanks, Peter. So that was our sort of way to have a little bit of comedic energy, not quite as doom and gloom for the last story of today. But if you'd like to hear more from us, including subscribing to our newsletter, as well as receiving information about subscriber-only podcasts and webinars, as well as events, then please subscribe to our premium via Patreon using the link in the show notes. A big thank you to Anson Evaluate for helping to produce this podcast. And if you'd like to produce your own podcast or webinar, or you'd be interested to hear more about Anson Evaluate services, please take a look at their website. You can find it at ansonevaluate.com. Just a reminder that these episodes are available on our website, our YouTube channel, podcast channels as well, such as Spotify, Apple Music, Amazon, Google Podcasts, and essentially anywhere you get your podcast from at this point. And please feel free to leave us a review. And if you have any questions about what we've talked about today, please feel free to email us at admin@digitallawuk.com. Thank you for listening, and we hope to see you again next week.